Welcome to District Attorney Charles Branson's informational program for victims and witnesses. Goals: educate victims and witnesses about the prosecution process, to reduce anxiety, to simplify the process. The crime is committed and the police are notified. The Lawrence Police Department, Douglas County Sheriff's Department, KU Office of Public Safety, Eudora Police Department, Baldwin City Police Department, or the Kansas Highway Patrol. A few types of crimes, for example, criminal non-support or public health-related crimes, are investigated by other agencies. The investigation. Investigation may include interviewing victims, witnesses, suspects, collecting physical evidence, visiting, viewing, photographing and measuring the crime scene, and identifying suspects through lineups. Police make an arrest or request a warrant when a crime is committed in a police officer's presence, or if he has probable cause to believe certain misdemeanors or a felony was committed he did not witness. The officer may arrest a suspect on the spot without an arrest warrant. The officer will later submit a charging affidavit to the prosecuting attorney suggesting potential charges. The affidavit or charging request is reviewed by the prosecuting attorney. Most cases begin with an affidavit. This is generally the first time the prosecuting attorney is involved in a case, unless he reviewed a search warrant or visited the crime scene. At this stage, the prosecutor determines whether a person should be charged with a crime, and if so, what the crime should be. Charges are issued by the prosecutor, not the police. The prosecuting attorney must thoroughly review all reports and records concerning the case, including witness statements. The prosecutor also reviews the suspect's prior criminal or traffic record. Occasionally, the reviewing prosecutor sends the case back to the police to conduct additional investigation. The complaint is issued. The prosecutor can issue a charge on a complaint if he reasonably believes that probable cause exists that the suspect committed the offense, but most prosecuting attorneys apply a higher standard, whether he reasonably believes he can prove the charge beyond a reasonable doubt at trial with the information known at that time. The warrant or summons is issued. The complaint is filed in the district court. The judge then signs a warrant, an order to bring the defendant before the court, or orders a summons be prepared and sent to the defendant, demanding they appear in court at a certain date or time. If a warrant was issued, the suspect will be arrested if not already in custody. The delay between the date of the crime and the defendant's arrest on an authorized charge can take any length of time. For example, if the defendant's whereabouts are unknown, or if he or she left the state of Kansas. District Court Arraignment. This is the first court appearance for any misdemeanor or felony. Once charged and arrested, the suspect appears in district court for arraignment. At arraignment, the defendant is told what the charge is, the maximum penalty if convicted, is advised of his constitutional rights to a jury or bench trial, appointed attorney, presumption of innocence, etc. The charging document is called a complaint. Also, the conditions and amount of bond are determined. In some cases, generally based on the nature of the charge, the judge imposes conditions on the bond, such as no contact with the victim. Bond is set in almost every case, but it is up to the defendant's own resources to post the bail money, which allows him to be released. Misdemeanor crimes. A misdemeanor is a crime in which the court can sentence a defendant to a maximum sentence of 1 year in jail, depending on the classification. At a misdemeanor arraignment, the defendant will be given a chance to enter a plea to the charge, plead guilty, plead not guilty, or stand mute. For example, remain silent, which is treated by the court as if the defendant pled not guilty. If he pleads guilty or no contest, the judge may sentence him on the spot or may reschedule the case for a sentencing date, which will give the probation department time to prepare a pre-sentence report including background information about the defendant and the crime, make a sentencing recommendation, etc. If the defendant stands mute or pleads not guilty, the case will be scheduled for a trial setting. Felony crimes. A felony is a crime punishable by death or by imprisonment in any state correctional institution, or a crime which is defined as a felony by law. At a felony arraignment in district court, the defendant does not plead guilty or not guilty. He is advised of his right to a preliminary examination within 10 days of the arraignment. The court reviews requests for court-appointed attorneys at the arraignment. Trial. A trial is an adversary proceeding in which the prosecutor must present evidence to prove the defendant's guilt beyond a reasonable doubt. The defendant is not required to prove his or her innocence or to present evidence, but may challenge the accuracy of the prosecutor's evidence. Bench or jury trial. Both the defendant and the prosecutor, who represents the people of the state of Kansas, have the right to a trial by a jury. Sometimes both sides agree to let a judge listen to the evidence and decide the case without a jury. This is called a bench trial. In a jury trial, the jury is the trier of fact. In a bench trial, the judge is the trier of fact. After the evidence is presented, the judge or jury will determine whether the evidence proved the defendant committed the crime. Steps in a trial jury selection. Residents of Douglas County are randomly selected and are summoned to the court as potential jurors. A blind draw selects 12 people from the group in felony cases and 6 in misdemeanor cases. The prosecutor and defense attorney question the jurors about their backgrounds and beliefs. The attorneys are permitted a limited number of peremptory challenges to the various jurors, or an unlimited number of challenges for good cause. After the 12 or 6 acceptable jurors remain, the judge administers an oath to the jury and reads basic instructions about the trial process. Opening statements. The prosecutor gives an opening statement to outline his case and evidence to the jury. The defense may give a similar opening statement or wait until later in the trial. Presentation of evidence. The prosecutor calls his witnesses, which the defense may cross-examine. The state then rests. The defense may call witnesses if it wants, and the prosecutor may cross-examine them. The defense rests. The prosecutor may present rebuttal witnesses or evidence to challenge evidence presented by the defendant during his case. The prosecutor rests. Closing arguments. The prosecutor presents a closing summary to the jury. Next, the defense attorney presents a closing summary to the jury. Finally, the prosecutor may present a rebuttal argument to the jury to respond to the defendant's attorney's closing summary. Instructions to the jury and deliberation. The judge gives the jury detailed legal instructions about the charged crime, the deliberation process, etc. Next, the jury deliberates and returns a verdict. If not guilty, the defendant is released from any requirements of the case. If guilty, the case moves on to the pre-sentence investigation and report level. Pre-sentence investigation and report. The court's probation department prepares a report for the judge summarizing the crime and the defendant's personal and criminal backgrounds. Generally, the victim is contacted for a recommendation of sentence. The probation officer concludes the report with a recommended sentence. Sentencing. Sentencing in Kansas varies with the crime and can be the most confusing part of the criminal process. Most often, sentences are at the judge's discretion. At the time of sentencing, the judge will consider the information in the pre-sentence report before determining the sentence. The parties may correct factual errors in the pre-sentence report and offer additional evidence relevant to the judge's sentencing decision. For certain felony crimes, the judge will consult the sentencing guidelines established by the Kansas legislature as a reference for framing an appropriate sentence throughout the state, considering factors of the crime and the defendant's criminal background to determine the minimum jail or prison sentence. The judge may consider different alternatives such as a fine, probation, community service, a sentence to jail or prison, or a combination. The judge must also order the defendant to make restitution to any victims who have suffered financial harm. Our victim witness coordinators can provide you contact and further information regarding GADUGI, WTCS, Victim Offender Mediation Program, ORS, Kansas Legal Services, counseling assistance, and other resources. On behalf of Douglas County District Attorney Charles Branson, thank you for your time, and please do not hesitate to contact the office if you need additional information.